Court is calling Adrian Vargas, 26 CR 795.
Good morning, Your Honor. Megan Salibi for the people.
Jennifer Chu on behalf of Mr. Vargas. He's present in custody at council table.
Thank you. Good afternoon, Mr. Vargas. Oh, go ahead.
I apologize. We are in VRA compliance, Your Honor.
Right.
I don't expect that the identified victim will be present here today, and I didn't see anybody on the WebEx.
Court will order sequestration. Anybody that you'd like exempt from sequestration? Any investigators or?
Not from the defense, thank you.
Not from the people, Judge. My primary investigator I'm going to call first. So, no, thank you.
Anything to address before proceeding?
Not for me, thank you.
No, Judge.
All right. People's first witness.
Your Honor, the people call Deputy Ellsworth.
Go ahead and swear you in before you take a seat. Do you solemnly swear or affirm under penalty of perjury the testimony you're about to provide this court will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You can take a seat if you just want to make yourself comfortable and make sure you're close to that microphone. And can you state your full name and spell your last name for the record?
Deputy Josiah Ellsworth, last name Ellsworth.
Thank you. Your witness, counsel.
Thank you, Your Honor. Deputy, where are you employed?
Adams County Sheriff's Office
How long have you been with the Adams County Sheriff's Office?
since 2022.
And what is your current assignment?
Patrol deputy.
Was that your assignment in March of this year?
Yes.
Briefly, what does a patrol deputy do?
We actively go out and proactively fight crime. We respond to calls to service and anything else that the community needs.
Okay. And are you post certified?
Yes.
Does that mean you've gone through all the training necessary to become a police officer in the state of Colorado?
Yes.
Were you post certified in March of this year?
Yes.
In general, what does it take to become post certified? Did you go to an academy or something else?
6 months of an academy, which I graduated in December of 2022.
In your role as a patrol deputy, did you come into contact with a person by the name of Deanna Bentoncourt on or about March 17th of 2026?
Yes.
And how did you get in contact with her?
It originated as a call for service. I contacted her via phone and met at Fire Station 11, which is roughly 69th and Pecos, West 69th and Pecos.
Is that in Adams County?
Yes.
And why was she at the fire station when you say it's a call for service? Is that a place that you typically respond, or how does that work?
Salud.
The call for service came, I believe she was at the substation. And upon my phone call, we arranged for a comfortable spot for her to meet, which the best spot was at that fire station in the lobby.
And when someone comes into the fire station, is it typically on a walk-in basis? Or to make a police report?
Typically, yes.
Okay.
Yeah.
So she was a walk-in. Did she come with anybody else?
Yes.
Do you know who she came with?
Her boss, Miss Romero.
And what was Miss Romero's connection to Ms. Bentoncourt?
Ms. Romero is Ms. Bentoncourt's boss. And so she drove her there.
Okay. Did you have an occasion to talk to Ms. Romero?
I did.
What did Ms. Romero say about why she was there?
Ms. Romero mentioned that she encouraged her to file a police report based on her ex-boyfriend's behavior and Ms. Betancourt was having a hard time coming forward because she was very scared. So Ms. Romero, being an advocate for Ms. Betancourt, encouraged her to call the police. And that's, in a sense, why we met at the fire station.
Okay. And did Ms. Romero express any concerns that she had?
She did. There was a comment made by Ms. Betancourt, something to the effect of she hoped her children had life insurance or they were her beneficiaries because she was worried her ex-boyfriend was going to hurt or kill her.
Was it your understanding that Ms. Romero, part of her job in working with Ms. Betancourt would have been to address issues like life insurance? Is that part of what Ms. Romero did at the job?
I do not know.
Okay. Is it your understanding that Ms. Betancourt came and spoke to Ms. Romero about life insurance?
Outside of what she mentioned in that brief statement, I don't know.
Okay. And we're talking about Ms. Betancourt. Is she whom you would consider to be the victim in the case that was reported?
Yes.
Okay. When you saw Ms. Betancourt, what was her demeanor like?
Distraught. She appeared very afraid. At times nervous. Hesitant is a strong word that comes to mind. She appeared hesitant, in fear that if she came forward, something was going to happen to her. And her demeanor, and she was very slow to speak and cautious at first. So yeah.
Okay. And when you say she appeared to be afraid, did you visibly see anything about her behavior that made you think she was afraid?
Yes, at times, upon questioning her, asking her what's going on, she would break down in tears.
And that was during her recitation of what had occurred to her?
Yes.
Okay. Was she soft-spoken or a loud person? How would you describe it?
Soft-spoken.
And when you spoke to her, was she by herself or was she, other than you, was she by herself?
Yes. Just me and her.
Okay. In general, and then we'll go into specifics, what was the nature of the report that she made?
In general, she was in a relationship with Adrian Vargas, who at the time was in Department of Corrections. She was receiving threats that she was afraid he was going to quote unquote kidnap her. He was upset over bets that were made in the prison and constant communication. Sun up to sundown, it appeared that he was nonstop calling her and she was afraid for her life. She had mentioned prior, there was a domestic violence incident in June of 2024. And based on the events of that day, with the continued communication, she was very afraid. So she wanted to file a police report.
Okay. Do you remember Adrian Vargas's date of birth?
I believe it's September 1995. I believe September 28th, 1995.
Okay. And let's talk a little bit in detail about the general summary that you just gave. Did she talk about the nature of her relationship with Mr. Vargas? Were they boyfriend, girlfriend, husband, wife, or something else?
She mentioned that they were boyfriend, girlfriend prior to him going to DOC. Since that time in June of 24, she was on an on again, off again relationship. She described it as an intimate relationship prior to him going to DOC.
You talked a little bit about a prior incident between them that occurred before Mr. Vargas went to DOC. What was the nature of that incident?
There was an incident at the house she was staying in, and her kids were present. The incident between her and Adrian, an argument became physical. He, quote unquote, dragged her into the room in front of her then 13-year-old daughter. He proceeded to strangle her, and she fought him, having to kick him off, and at which point the 13-year-old had to call the police.
And were the police, you said that the 13-year-old called the police. Was he arrested based on that incident or for another reason?
According to the reports that I read, he had active warrants at that time that police responded to the house.
Are you aware of that case? And if you're not, it's fine, but are you aware of whether that case of strangulation went forward at all?
I don't know. Yeah.
Okay. And being arrested on his warrants, was it your understanding that he was on parole at that time, or do you know the nature of those warrants?
I believe the nature of the warrants were domestic violence. I don't know if he was on parole or anything at the time.
Okay. Were you aware of whether he went back to DOC, Department of Corrections, as a result of those warrants?
I don't know.
Was he in custody from that time on, to your knowledge?
I believe so. Yeah.
Okay. And was he in custody in Department of Corrections or somewhere else?
I believe it ended up in the DOC I believe probably from the Adams County Jail if he was arrested by our deputies.
Okay. During the time that the defendant was in Department of Corrections, did he have contact with the victim?
Yes.
Were there times when she stopped having contact with him?
The victim mentioned that she tried to, at times, stop communication with him, with Adrian.
Was she successful when she tried to stop contact with him?
No.
And why?
There was times where she actually changed her number, but through a relationship that the victim had with Adrian's mother, there were times where the victim, as she explained it, would be on a three-way call, or on a call with the mother, and then the mother would three-way with Adrian, and exposing her new phone number. And this went back and forth, over the hour, 2 years or whatever. So.
Okay. And if the victim didn't call Mr. Vargas, what would he do? Like if he reached out to her and she didn't answer or she didn't call him, how would he behave?
It appeared as if the way she described it, he would call nonstop from the prison. And when he would speak with her, it would be in a manner that he was very angry, as she described.
Did he say anything specific to her when he would get angry with her? Were there specific threats that she reported?
The threats there were, based on when she came forward to me, there were threats that he knew her schedule, that he was going to kill her, that I'm sorry, I'd have to look at my report to refresh my memory, but it was along those lines. Yeah.
Okay. Did he have a specific threat or a go-to threat that he would make to her?
The way she described it as, and I don't know if this was a verbal threat or a physical threat, but based on the past that she had with him, strangulation was his go-to. So she confirmed at least the one time he did strangle her. And then when they would argue, she described that was his go-to threat.
Let's talk a little bit about what happened in March of 2026. What occurred that compelled her to make a report to the police?
Can you repeat the question?
What happened in March of this year that caused the victim to go to the fire department and to make a report?
So the victim stated that she was placing bets for Mr. Adrian and outside of the jail and then or the prison, and then the winnings from that would go to Adrian's friend. In turn, that friend would send the money to the prison, and he would use that for his personal commissary or whatever. There was as the victim described it, a discrepancy in how much money he made off one bet in March. She would bet off the Bet 365 app, and the discrepancy, he believed he made $320 some, and he actually only made $32 off the bet, and he became irate, cussing at her over the phone. Like I said, threatening that he knew her schedule, knew where the kids went to school, and in turn, even some of his friends were reaching out to the victim, threatening that Adrian better get his money or else, basically. And that was the catalyst for her to make the police report, because she was in fear for her life.
And this wasn't the only bet that she had made at his direction, is that correct?
Correct.
Okay. So this was something that had been going on for a little bit of time. Is that your understanding?
Yes.
Okay. Do you recall what date this bet was placed?
I do not.
Okay. Would it refresh your memory to look at a screenshot of that bet?
Yes.
Okay. And may I approach with what's been marked as People's One?
Yes.
If you could take a look at that, do you know what that is?
Yes.
Firstly, does it refresh your memory about when the bet occurred?
Yes.
What date did that bet occur?
March 15th, 13 hours,
Was it of this year or some other year?
2026.
Okay. And you said you knew what it was. How do you know what that is?
This is a screenshot that the victim showed me of her placing the bet, where the return was $32.44.
Your Honor, the people move to admit for the purposes of this hearing, People's One.
Any objection or voir dire?
No objection.
Court will admit People's Exhibit 1 without objection.
Thank you. And you had previously testified that the defendant thought that the bet was a different amount. Is that correct?
Yes.
Okay. And that there should have been more money from that bet. Is that also correct?
Correct.
You had mentioned previously that the victim reported that friends of the defendant were reaching out to her, or she was concerned about that. Do you remember that?
Yes.
I approach with people, Stu.
Yes, you may.
Thank you. Look at People's Exhibit 2 and tell me if you know.
Yes. This is a screenshot of a text message that she received from one of Adrian's friends.
Okay. And that's connected to this case?
Yes.
Is it one of those messages that she referred to from one of his associates,
Yes.
meaning Adrian's associates?
Yes.
Okay. Your Honor, the people move to admit Exhibit 2.
Any objection or voir dire?
No objection.
Court will admit People's Exhibit 2.
In that exhibit, does that individual refer to an individual by the name of Tiny Payasos?
Yes.
And who did you come to learn is Tiny Payasos?
Adrian Vargas.
Is this a message that Ms. Bentoncourt reported came to her phone?
Yes.
Okay. And what did, if you could just read that message into the record, what does it say, Detective?
Hey, what's up, foo? This is Tiny Payaso's homegirl. Check me out. Don't be playing with the homie's money or there be a fucking problem and palabra. I'll get your address from the homie. Don't fucking play around. FR. Which, for real.
Is this all connected to and around the time of that bet that occurred on March 15th of 2026?
Yes.
Okay. Is it an example that the victim gave of somebody that reached out to her when the defendant was upset about the money that he thought she should have obtained from the bet?
Yes.
Okay. Why did contact from the defendant's friends concern the victim? Why was she concerned about that?
Because he was incarcerated, she was worried that his connections on the outside were going to show up at her house or place of work or kids' school, etc. That he was pulling strings from the outside that could potentially, like I said, kill her or fear for her life.
Was there some concern about these individuals in particular?
Yes.
What was her concern?
They're gang affiliated and they knew, Adrian knew where she lived. So in turn, they would know where she lived.
Detective, I'm just going to go through some exhibits with you. May I approach Judge with Peoples 3?
Yes.
Okay. Three. Moment to look.
Good.
Do you know what those are?
Yes.
What are they?
These are screenshots from the victim's phone of the numerous phone calls from DOC, Adrian calling her.
And is that part of what you collected from the victim in this case?
Yes.
Your Honor, people move to admit People's Exhibit 3.
Any objection or voir dire?
No objection.
Court will admit People's Exhibit 3 without objection.
Do these reflect, Deputy, the number and types of calls that she was receiving, that she reported to you were continuous and ongoing from the defendant?
Yes.
And do you know what date these calls were made?
So I met with Ms. Betancourt on March 17th, 26. Then these numerous phone calls were time-stamped, which to me, I mean, as an iPhone, that they were from that day, March 17th, because they were time-stamped. There was additional phone calls that said yesterday, which would have been Monday, March 16th, and then back to Sunday, which would have been March 15th.
And Your Honor, I'm just going to ask that the court take judicial notice that Tuesday or March 17th, 2026 was a Tuesday.
Any objection to that judicially noticed fact?
No.
And may I approach with People's 4 and 5?
Yes, you may.
Rick, you just mentioned additional calls. Can you take a moment and look at People's 4 and People's 5? Thank you. And do you know what those are?
Yes.
And are those the calls that you just referred to that came the day before and on Sunday?
Yes.
Okay. Are those calls that you obtained from the victim in your investigation of this case?
Yes.
Your Honor, the people move to admit 4 and 5.
Any objection or voir dire?
No objection, thank you.
Court will admit People's Exhibits 4 and 5.
Thank you, Judge. May I approach with People 6?
Yes.
Approaching you with People 6. And do you know what this is?
Yes.
What is it?
This is a screenshot from the victim's phone, a text message between her and her boss.
Okay. And is this also something that you obtained from the victim in the course of investigating this case?
Yes.
Does that text message reflect in part what you had testified to about the concerns that Ms. Romero, her boss, had?
Yes.
Your Honor, the people move to admit Exhibit 6 for the purposes of this hearing.
Any objection?
No objection, thank you.
Court will admit People's Exhibit 6 without objection.
Just one moment. I apologize.
I mean, you can play it like,
No.
it's 30 minutes long.
I think it's
I mean, sure.
okay. Your Honor, I did talk to defense about this. I didn't deposit it prior to. In talking with the witness this morning or today, I have a call from the Department of Corrections that I do want to play for the court. It is about 17 minutes long. I can divert to the court as to whether I play a portion of it and then submit the entire thing or what the court prefers. And defense.
Ms. Chu, any position or record?
Your Honor, it's 17 minutes long. Obviously, this isn't really what I wanted to do this afternoon, was to listen to the 17-minute long recording when it could have been deposited ahead of time. Ultimately, I will defer to the court because regardless, the court's going to hear it. Obviously, I have preferences on what I hope that we can do, but it doesn't
Okay.
matter what I think.
It does.
What I'm trying to avoid is putting the detective in a position where he's having to remember everything that was said on the call. He does have a copy of I have a copy of the evidence.com Axon transcript as well. I just didn't want to put him in a position of having to recall all those exact words. So I apologize that I didn't deposit it beforehand.
That's okay. My only concern, we've got 2 PHs going this afternoon. So given the length of that, I mean, if you want to play any short, relevant snippets that you want the court to hear, but
Okay.
I'd rather just
Great.
take it under advisement than have the chance to listen to the whole thing if the parties think I should listen to the whole thing.
Right. Do I use this to play something?
Yes.
Do you have a disc too?
I
Or
don't. I'm going to play it from my computer, if that's okay.
I think he needs.
I think he needs to be admitted first.
No, I'm going to, I'll go.
Okay.
Yeah.
So we put it there and then changes to
Okay,
here and then you
great.
should have access.
Detective, did you have a chance to listen to a portion of a call from Mr. Vargas to Ms. Bentoncourt for the purposes of authenticating that call?
Yes.
Was that prior to this hearing?
Yes.
And did you recognize it as a call that she had provided to you as part of the investigation in this case?
Yes.
And is this the call that you touched on previously, where you talked about specific threats that he had made to her?
Yes.
Okay. Your Honor, the people moved to admit, I believe it would be 7.
Any objection or voir dire?
No objection.
To refuse charges, press 2. If you would like to permanently thank you for using service, you may start the conversation now. Can you send that picture to the homie? I don't have no picture. You don't have a picture of the last that you did where you want $322? What? $322? What are you talking about? I never said $322. I never said that. Do you see how you make up these stories and then you throw them out there at everybody and you make me seem like this bad person? I never said $322. I never said that. I never said that. I never said that, Adrian. Never said $322. Why can't you send me every other picture besides this one? Because you're lying, and I don't have to do anything for you. I never said $322. You don't have. Hey, but I'm not. The thing is that you're gonna get me in trouble. You're gonna get some people in trouble all because of $200. Sure, but where are you getting $200 though? First you said 300. Now you're saying 200. What are you talking about though? Okay, good. So 100 pays 200 between anywhere. 100 pays anywhere between $320, $22 or $360. No. Okay, that's what 100 pays. See, that's what you're assuming, though. That's what you're assuming, though. That's what you're assuming, though. And I'm gonna prove you wrong, and then I want you to leave me alone. Like I said, I'm gonna prove you wrong, because there's no $300. There's no $200. No, I didn't. You're talking about the bet. I have money, Adrian. I have a job. I work. I got my taxes. What are you talking about? That bet, let me talk because you do all the talking all the time. You do all the talking all the time. Let me talk though. You said I put the bet in there. I didn't put no money. No, I didn't put no money because you know I don't do bets. I never said that. You're making up all these stories. That's not true. The bet you told me to put in, it went in. I told you that. It did not. I never once said in my life, and I swear on my kids, I never said you won $200, $300 on that. I did not say that. I never once said that. You're making up these stories. Yes, you did. You said $10 gives $300. Where do you get that from? Where do you get that from? You were lying to me, and I'm telling you that you're telling me that you take a $10 bet for $22. I'm telling you that didn't happen. I'm telling you that what I know is that you fucking put a $50 bet because I told you to put it. I did not. You said $10. I did $10 like you told me to. I did $10 like you told me to. Yes, you did. Yes, you did, Adrian.
Deputy, is this does this call correspond to the exhibit that shows the bet that was placed
Yes,
and the argument that they're having over $10 versus $100, $32 versus $300?
yes.
All right, I'm just going to skip ahead a little bit.
I know about it. I never said I know about it. I'm saying you're a liar. You're lying. You're lying. You're lying. I didn't say I know anything about it, but because I'm not the one that's addicted to that.
I mean, you. Why are you doing this?
What does that have to do with anything?
Hey, because. Just. People think. And you're a cop. You would sleep at 7:30. I'm having 8. You know what I mean? And for someone being like that, with them being able to eat, sleep, fucking, you, to think, is it worth it? Because, man, this is why people come back to prison, because people they don't forget about it. You know, he's probably gonna fucking go. He's gonna forget about it. And I'm gonna think about this shit every motherfucking day when I'm blowing up fucking on Alejandro. Just so he can call fucking these different numbers for me, just so he can get into contact with people that I haven't talked to in years. Just so he can fucking be with this person, be with this person, be with this person. And I told you before that I don't want to fucking no more, but you're forcing me to contact these people. I'm not fucking reached out to in a long fucking time, and if I can get these people to say it's fucking worth it. No matter how many times you talk like this, I'm a woman beater. I'm a woman herder. Okay, I haven't made, I haven't slept.
You're saying all this stuff though. You're making lies. You're lying though. You're lying. To do nothing for you, Adrian, but you're lying. What?
At the gas station. I'm taking her with me.
Thank you, Judge. And I'm just stopping it at 9:02. And the call itself is 17 minutes and 3 seconds long. Detective, you previously had talked about the victim identifying the defendant. Do you recall that?
Yes.
My approach with People's Aid.
Yes.
Yes. This is a photo that the victim had on her phone. She showed me of her and Adrian.
And how did it come about that she showed you that photo?
I asked her to positively identify who Adrian was.
Did she do that at that time?
Yes.
And and are you yourself able to identify Mr. Vargas in the courtroom here today?
Yes.
And are you able to point out where he's seated and the item of clothing that he's wearing?
Yes.
And if you could do that at this time.
That table over there with the orange and white striped shirt.
Your Honor, let the record reflect, subject to cross-examination, that the witness has identified the defendant.
Subject to cross-examination, the record shall so reflect.
And Detective, this is an Adams County Sheriff's case, is that correct?
Yes.
Did this incident occur in Adams County? Is that why you responded to it?
Yes.
Okay. I want to talk to you just briefly about what the victim did in response to the defendant's actions. Did she take measures after this to protect herself?
Yes.
What are some of the things that she did?
She changed her home address and she changed her phone number.
Did she, after this incident occurred, report that there had been additional contacts from the defendant?
Can you restate the question?
After this incident occurred, did she report any additional contacts from him?
After she made the report with me,
Yes.
she mentioned that there were no additional contacts after she changed her information.
Did she talk to you about whether she had the Securus app or not?
She did. Yeah.
What's the Securus app?
I believe it's the DOC app to contact home.
Did she receive any additional calls through that Securus after she reported this?
Yes, she did. Yes.
And do you recall when that was?
I don't recall when it was. She did mention that while she had them in the app, the messages in the app, she did not open them, and she actually deleted the app to cut off communication with Adrian.
Just a moment, please. Aaron, I have no further questions at this time.
Cross-examination.
Thank you. Good afternoon, Deputy Ellsworth.
Good afternoon.
Let me just get organized. Okay, so I want to start with, you just testified that you were able to identify Adrian Vargas in court. Do you remember that?
Yes.
And then you pointed at him and said this was Adrian Vargas that Ms. Betancourt was referring to, right?
Yes.
Fair to say you've never met Mr. Vargas before?
No.
You've never spoken to him?
No.
Then how are you able to identify him?
Through photos and through Department of Motor Vehicle pictures.
How are you able to identify that this was the Adrian Vargas that Ms. Betancourt was talking about, the same person?
Through the means I just mentioned.
Okay. But not through any personal knowledge?
Correct.
Through police databases?
Yes.
Okay. Now, let me back up a little bit. The police databases that you said you used the DMV photo database?
As one, yeah.
Okay. The DMV photo database that you identified Mr. Vargas with, you did not show that picture to Ms. Betancourt, right?
Correct.
What other law enforcement databases did you use?
Lumen.
Okay. And the photo that you found on Lumen, you did not show that picture to Ms. Betancourt, right?
Correct.
Now, you took the initial report on March 17th of 2026, right?
Yes.
And Ms. Betancourt had gone to the fire station, right?
Yes.
And you had ultimately met her there.
Yes.
Now, Ms. Betancourt initially described an incident that happened on June 14th of 2024, right?
Yes.
And this was about almost 2 years prior, right?
Correct.
And that was the day that Mr. Vargas was arrested. He was taken to jail and then sent to prison, right?
Yes.
And she never saw him in person again after June 14th of 2024, right?
I don't know.
Okay. Ms. Betancourt claimed that Mr. Vargas had tried to strangle her, right?
Yes,
And you're aware that Mr. Vargas was never charged with domestic violence in that case, right?
correct.
And you're aware that Mr. Vargas was never charged with strangling Ms. Betancourt, right?
Correct.
And as a patrol deputy, you know that if there's probable cause for a DV arrest, you have to make the arrest, right?
Yes,
And instead, Mr. Vargas was jailed and arrested on 2 outstanding warrants, right?
yes,
As well as 2 offenses against law enforcement, obstruction and resisting.
correct.
Now, you yourself didn't respond to that supposed strangulation incident back on June 14th of 2024, right?
Correct.
Now, Ms. Betancourt claimed that after June 14th of 2024, she had tried to initiate separation from Mr. Vargas, right?
Yes,
But to be clear, Mr. Vargas, from June 14th of 2024, when he goes to jail, up until the day that Ms. Betancourt comes to see you at the fire station, which was March 17th, 2026, Mr. Vargas was incarcerated, right?
I believe so, yeah.
He was in either jail awaiting transport to prison or in prison, right?
Correct, yeah.
Now, even though, according to Ms. Betancourt, she tried to initiate separation from Mr. Vargas, she continued to talk to him, right?
Correct.
Now, I want to talk a little bit about how inmates are able to talk on the phone while they're in DOC, okay? So Mr. Vargas had a prison tablet, right?
To my knowledge, yes.
And this is all according to Ms. Betancourt, right?
Correct.
You didn't do any individual research on how people are talking to each other.
I have experience working in the jail, and also there were several attempts to reach out to DOC.
Okay, that wasn't my question. My question was, you don't have any personal experience of how inmates communicate in DOC, right?
Not in DOC, no.
Okay. And so the information on how they're communicating really is information you're getting from Ms. Betancourt, right?
Yes,
And so Ms. Betancourt claims she was able to call Mr. Vargas on his prison tablet, right?
yes,
And Mr. Vargas was also able to call Ms. Betancourt on the prison tablet, right?
yes,
Now, Ms. Betancourt claimed that she was not successful in trying to stop communication with Mr. Vargas, right?
correct,
And she claimed that she had changed her phone number, right?
correct.
Do you remember how many times she changed her phone number?
I don't recall.
Okay. Did she tell you or you just can't recall?
She told me, but I don't recall.
Okay.
Yeah.
She told you the number of times she changed her phone number.
Correct.
And after Ms. Betancourt changed her phone number, she then gave her new number to Mr. Vargas's mother, right?
Either that or they asked for it, or he asked for it. There was some way that he obtained it from prison, yes.
Either way, Ms. Betancourt is giving her number to somebody. Somebody's then giving it to Mr. Vargas. Is that fair?
Correct.
Okay. It's fair to say that Ms. Betancourt didn't have to give her new number to Mr. Vargas's mom, right?
Correct.
She has free will, right?
Yes,
And that's ultimately a choice that she made.
correct.
She also talked about how there would be a 3-way call between Mr. Vargas, Mr. Vargas's mother, as well as Ms. Betancourt, right?
Yes,
And she claimed that was another way that Mr. Vargas would be able to get her new number, right?
yes,
Again, she didn't have to answer that 3-way call, right?
yeah, yes. I don't know. I wasn't there. So.
Okay.
Yeah.
Well, you don't have to answer every call you get, right?
Right.
Regardless if it's a 2-way call or a 3-way call, right? Is that a yes?
Yes,
Okay. And it's fair to say, again, that's a choice she made, right?
yes,
Because again, she has free will.
yes.
And again, she's the person who's free in this case, right?
Correct.
Because at the time, Mr. Vargas is incarcerated.
Yes,
Now, the dates that are charged in this case are March 15th through March 25th, right?
correct.
Okay. Do you know what DOC facility Mr. Vargas was at during the dates charged?
Centennial South.
Okay, Centennial South. And do you, I know you said you tried to do some research. Do you know how inmates specifically at Centennial South make phone calls?
I do not.
Okay. Now, do you know, and you may not know, but The person who is receiving these calls, in this case, Ms. Betancourt, does she need to be on a phone list for the inmate?
I don't know.
Okay. And do you know whether the person who's receiving the calls, in this case, Ms. Betancourt, can block the calls from the facility?
I don't know how that works.
Okay. And you're the lead detective on this case, right?
Yes.
Now, when a person calls from prison, these calls are recorded, right?
To my knowledge, yes.
Okay. In fact, when we listen to the recording, there's kind of a warning before you start talking, right?
Yes.
And that warning says this call is subject to recording, right?
Yes.
Similarly, in that call log that we saw, there's a warning that says this is subject to recording, right?
Correct.
Now, the photos of the calls are the ones that Ms. Betancourt picked out to show you, right?
Yes.
It's over a 3-day period, right?
Yes.
I think you testified it was the 15th, the 16th, and the 17th.
Correct.
She didn't show you how much they would be talking generally, right?
Correct.
And this argument about the bet, it occurs on the 15th, right?
Yes.
Ms. Betancourt doesn't pull her call log to show how many times they were talking the 14th, the 13th, the 12th, or the 11th, right?
Correct.
And so you don't know if it was common for them to be talking all the time, right?
She described it. These calls happened all the time. Yes.
Okay, so these calls did happen all the time, right?
Correct.
The calls that she would pick up, right? Is that a yes?
Yes.
Sorry, we're just recording this for the future.
I got it.
Okay.
Yeah, I got it.
So the calls that she was picking up, she was picking them up, right?
Yes.
From the DOC facility.
Some of them. Yeah.
Okay. Now, Ms. Betancourt, she had been placing bets for Mr. Vargas, right?
Yes.
And she had told you that if she has this belief that if she doesn't do the bet, Mr. Vargas will then hurt her, right?
Yes.
And she had described past situations where, and I think you testified, he would yell, he would threaten to kill her. And as you wrote in your report, that he would also beat her up, right?
Correct.
And these were threats that she claimed that he was making, right?
Correct.
Now, these past time, and she believed that based on her past experiences with him, right?
Yes.
Past experiences being before June 4th, the June of 2024, right?
Yes.
Because that's the last time she really saw him in person, right?
I believe so. Yeah.
Now, it would have been when he was out of custody, right?
Correct.
So when he says that if she doesn't do as he says, he will hurt her, he'll kill her, or he'll strangle her, he can't do that while he's in prison, right?
Through other connections, he can find a means. Yes.
That wasn't my question. My question was that he himself can't accomplish that in prison, right?
You're correct.
Okay. And that's because he's in custody, right?
Correct.
Can't just beat her up while he's in Centennial South.
Correct.
Again, she's the one who agreed to place these bets, right?
Yes.
Because she has free will, right?
Correct.
And she made that choice for herself.
Yes.
Now, Ms. Betancourt also told you that Mr. Vargas knew her work schedule, her school, her kid's school schedule, and when she's alone, right?
Yes.
And that's because she had told him that information, right?
I don't know.
Okay. Well, let me use an example. He's not out on the streets Googling her work schedule, right?
Correct.
Because you can't Google while you're in prison.
Correct.
He's not out on the streets following her around trying to figure out what her work schedule is.
Correct.
He's not on the streets figuring out when her kid's school schedule is, right?
Correct.
And so that information that he had came from her, right?
Essentially,
Okay.
they were in a relationship. So yes.
Okay. And again, he's in a locked facility hours away, right?
Correct.
Do you know where Centennial South is?
I believe it's in Canyon City.
And how far is Canyon City from Adams County?
I don't know.
Okay. You've never done the drive to Canyon City?
No.
Now, you told us, so I want to talk about this bet that happens on March 15th, okay? So that's the recording that we just listened to, right?
Correct.
And you wrote in your report that she had played a portion of that recording for you, right?
Yes.
But she didn't play the whole thing, right?
Correct.
And she was the one who decided what parts of the recording to play for you, right?
Yes.
I'm not necessarily talking about the parts that we're going to play for the judge, but the parts that Ms. Betancourt gave to you. right?
Correct.
Okay. Now, it's fair to say that Mr. Vargas is upset because he thinks that Ms. Betancourt has stole some money from him, right?
It's fair to say.
Fair to say he said some fairly unkind things, right?
Correct.
And she doesn't hang up on him, right?
Correct.
In fact, he ultimately hangs up on her.
I don't know.
Oh.
I don't know how it ended exactly. I don't recall. Yeah.
Because she didn't play the whole thing for you.
I heard the whole thing, but I don't recall how it ended.
Okay. She continued to deny stealing from him throughout this conversation, right?
Yes.
And she recorded the conversation.
Correct.
That wasn't a conversation that you got from ordering the call records from the prison, right?
Correct.
Now, I want to talk about this text call from Tiny Payasos. Okay?
Okay.
You told us that Tiny Payasos, you learned that that's Mr. Vargas.
Correct.
How did you learn that?
Through research.
What type of research?
Through the investigation of the case.
You're going to have to be more specific for me. Who told you that?
Through past reports in Lumen,
Okay.
law enforcement database.
Okay. So you don't personally know that Tiny Payasos is a name that Mr. Vargas uses, right?
Not personally, no.
It's through something called Lumen where someone else has inputted this information.
Correct.
Okay. And you yourself did not independently verify whether Tiny Payasos is Mr. Vargas, right?
Correct.
Because again, you never spoke to Mr. Vargas in this case.
Correct.
Now, after this argument that happens on March 15th, it's fair to say that Mr. Vargas and Ms. Betancourt, they never speak to each other again, right?
Correct.
They never talk one-on-one again.
It's fair to say. Yeah.
I say one-on-one, but I'm talking about the prison phone to Ms. Betancourt, right?
Yes.
After this argument or fight they had, they just stopped talking.
Yes.
Okay. You did do some follow-up with Ms. Betancourt on March 31st of 2026, right?
Correct.
And during this follow-up, and according to her, he sent 3 messages through a prison messaging system titled Securus, right?
Yes.
Are they text messages, voice messages? What kind of messages are we talking about?
I don't know. I've never used that app, so I don't know.
Okay, you've never used Securus?
No.
And you don't know how Securus works at Centennial South?
I don't. Mm-mm.
And you don't know if Securus messaging is the same phone system that they use when Mr. Vargas is calling on his tablet, right?
I don't know. Yeah.
Okay. Now, according to Ms. Betancourt, she didn't open them, right?
Correct.
And we don't know if it's a voicemail, a text message, or what, right?
Right.
She doesn't know the content of them.
Correct.
She didn't save them.
Correct.
And so she doesn't know if it's an apology for him yelling at her on March 15th, right?
Correct.
And you don't know when the date of these 3 messages, when they were sent, right?
Right.
Now, and also she failed to document them, right?
Failed to document in what way?
She didn't if they came on her phone, she didn't screenshot them like that call log that you have.
That's correct.
She just deleted them.
Correct.
Now, during your follow-up conversation with Ms. Betancourt on March 31st, she confirmed that she has not received any additional phone messages from Mr. Vargas, right?
Right.
Did she tell you she'd received a letter from Mr. Vargas apologizing for his behavior?
She did not.
Okay. So she didn't tell you that he had written her a letter where he told her he misunderstood the amount of the bet of the bet and how much she won, that he was sorry and that he would leave her alone.
That was not mentioned to me. No.
Okay. Those are my questions. Thank you.
Any redirect examination?
Briefly.
I'm going to hold you to it.
Detective, you had mentioned that you did some research to verify Tiny Payasos. Do you recall that?
Yes.
Does part of that include pulling someone's criminal history?
Yes.
On criminal histories, do people have AKAs?
Yes.
And is Tiny Payasos one of the AKAs on that history
Yes.
for Mr. Vargas?
Yes.
And defense counsel asked you about that follow-up conversation. In that follow-up conversation at the end of March, did the victim describe to you that she'd actually sent money to one of Mr. Vargas's associates?
Yes.
And was this in response to the threats from Mr. Vargas that she should return the money to his associates?
I do not know how she was supposed to return the money. That was not discussed at length, no.
But she indicated that she actually did give money to them.
I don't recall.
Okay. Oh, thank you. Nothing.
May this witness be excused?
Yes,
You want to hand those over to me? Any additional witnesses?
just Deputy Neal. Thank you.
Yes, sir. Thank you.
Swear you in before you take a seat. You solemnly swear or affirm under penalty of perjury the testimony you're about to provide this quote will be the truth, the whole truth, nothing but the truth.
I do.
Thank you. You can take a seat if you want to make yourself comfortable. Just make sure you're close to that microphone. You could state your full name and spell your last name for the record.
I'm Detective Brandon Neal, and last is Neel.
Thank you, your witness counsel.
Thank you. Detective, were you employed?
I am employed with the Adams County Sheriff's Office
How long?
since 2018.
What's your assignment?
I'm currently assigned to the Detective Division.
Was that your assignment in March of 2026?
Yes.
And are you post-certified?
Yes.
Were you post-certified in March of 2026?
Yes.
Did you get involved in an investigation of a case involving Adrian Vargas on or about March of 2026?
Yes.
And as part of the work that you did on the case, did you arrange for a forensic interview to occur of Deanna Betancourt?
Yes.
Do you recall when that occurred
I believe it was May 8th.
of this year?
Yes.
And where did it occur?
At the Ralston House off of 112th in North Glen.
In that forensic interview, you're observing, correct? You're not in the room, is that right?
Yeah, I'm not in the room. I'm observing from a separate room.
Okay. And did you observe that entire interview?
Yes.
Okay. Did the victim talk about how she met the defendant?
Yes.
Okay. And did she also talk about how soon after they met that he moved into her place?
Yes.
And how soon was that approximately?
I was going to say, she did not specify exact dates or exactly how long it was. She just said it was very fast after they had started talking.
At that time, did she talk about the defendant being on parole?
Yes.
And did he let her know that he was in violation of his parole at that time?
From my understanding was she was made aware of that when she let him live with her.
Okay. And do you recall, was that in June of 2024?
I don't recall exact date of when she said.
Okay. At some point after he moved in, was there a time where the police were called?
Yes.
Do you recall when that was?
I don't recall the exact date right now.
Would that have been on or about June of 2024?
Objection leading.
Response?
Here, and I'll withdraw it. Do you recall why the police were called?
Yes.
Why?
It was to a domestic violence incident.
What was the nature of that incident?
I don't recall the exact nature or the exact call notes from it, but it was something along the lines of a potential physical and domestic violence incident.
Okay. When the police were called, was the defendant, did the victim talk about the defendant being taken into custody?
Yes.
Okay. And did she describe that after he was taken into custody, he went to the Department of Corrections?
Yes.
When the defendant went to the Department of Corrections, how did he communicate with her?
At first, it was from what she had stated in the interview, it was through letters and phone calls. And then once he was moved facilities, he was issued a tablet. And then through the tablet, they were able to message each other.
Did he make phone calls through the tablet too?
I don't know if the phone calls were through the tablet, but she did state that they were still in communication via phone as well as through the messages.
Okay. And how often did she describe that the phone calls occurred?
She said it was very frequent. And at times, if I remember correctly, it was like daily.
And did she describe whether the defendant had any expectations about whether she would answer his phone calls?
Yes.
What were those expectations?
That when he called, she would answer. Otherwise, he would become upset.
Does this include that she had to answer calls while she was at work?
Yes.
Did she talk about whether she was allowed to be on the phone at work?
Yes.
And was she?
No.
Okay. How did she deal with this?
She, if I remember correctly, she stated that she tried to explain that she wasn't always able to answer her phone. And then the idea was brought up for her to get some kind of like earpiece or Bluetooth, something along those lines. So that way it wouldn't be as obvious she was on the phone.
Who gave her that idea?
Mr. Vargas.
So did she describe during her interview essentially being in a situation where she had to answer his calls anytime that he reached out?
Yes.
During some of these calls, was the defendant asking her to make bets for him?
Yes.
Do you recall her describing how that worked?
That he would call and ask her to place bets via a phone application. Then it would be trying to get her to pay attention to the games to see. So that way, if something had changed and she needed to cash out the bet early or anything like that, that way she could.
When you say pay attention to the games, did she describe that she was required to watch the games?
Yes.
And even if she was at work?
Yes.
Okay. Were there some successful bets that were made?
Yes.
And did she talk about a bet that occurred in March of 2026 that started at arguments between her and the defendant?
Yes.
After the argument that they had, and did the victim keep her same number or did she change it?
She had changed her phone number.
Okay. Did she talk about other times that she changed her phone number?
I don't recall at this time. I just know of 2 times that she's changed her phone number.
And is the reason she changed the phone number so that he could not contact her?
Yes.
Okay. In that bet in March of 2026, the victim described that she made a mistake in placing that bet.
Yes, there is some kind of miscommunication due to her poor phone signal.
Was it about the amount that she was supposed to bet?
Yes.
In response to this mistake, did she describe that friends of the defendant contacted her?
Yes.
Why were they contacting her?
She stated that the bet amount, that I guess it was supposed to be higher than what she had made it for, and the friends were now accusing her of stealing money.
Did she discuss that during this time in March that she went to her boss at work, Ms. Romero?
Yes.
Why did she go to Ms. Romero?
To talk about her life insurance policy and potentially having her child assigned to it, or one of her children.
And what did she describe? Why did she want it assigned to one of her children?
Because she was afraid something was going to happen to her.
And what did she mean by something was going to happen to her?
She was afraid that one of the friends was going to find her and attack her, or her quotes, beat her up.
Are you aware of whether after this incident, the victim relocated?
Yes.
Are you aware of whether she changed her phone number after this incident?
Yes.
Did she describe some of the impact that this had had upon her?
Yes.
And how did she articulate the impact this had had on her?
Objection relevance.
Emotional distress, Judge.
Overruled. You can answer.
Okay. She was upset and scared.
Was she scared just for herself or for her children as well?
For herself and for her children.
And during this time in March of 2026, were you aware of Mr. Vargas's status, whether he was in or out of custody?
From my understanding, he was in custody within the Department of Corrections.
And were you aware about whether he had an upcoming release date at that time?
Yes.
And do you recall approximately when that release date was compared to this incident?
It was in April of 2026.
And so it was your understanding he would be released from the Department of Corrections at that time, is that correct?
Yes.
Okay, just one moment, Judge. In addition to the incident that you described, that was a physical altercation where the police were called, did she describe any other incidents of domestic violence between herself and the defendant?
Yes.
What did she describe? Were there two incidents she described in addition to that one?
Yeah, in addition to that one, there was two other incidents.
What was one of those incidents?
One of those was a time prior down, and I believe somewhere in the Colorado Springs area. She could not remember exactly where. There was an argument that had started between them that had turned physical when he had grabbed her by the back of her neck and also caused a scratch mark.
And you mentioned another incident as well. Do you recall that one?
Yes, it was another, one of the other incidents she described was they had gotten to an argument. She went to get into her vehicle to leave. He came out of the house with a baseball bat and threatened to smash all of the windows of her vehicle if she drove away.
Just a moment. Judge, I don't have any further questions at this time.
Cross-examination.
Thank you. Right. Good afternoon, Detective Neal.
Hello?
Hi, are you the lead detective on this case?
Yes.
Okay. And so you're responsible for the follow-up investigation, right?
Yes.
Okay. You just testified about two incidents that Ms. Betancourt described, an incident that happened in Colorado Springs and another incident that happened with a baseball bat, right?
Yes.
Those incidents would have happened no later than 2024, right?
I don't believe so. Yeah. Yes.
Okay, I think that was really confusing the way I said it, but essentially Mr. Vargas went to prison in June of 2024 and he's been incarcerated ever since then, right?
From my understanding.
Okay. And so if she described these two situations where he wasn't in prison, they must have happened before he went there, right?
Yes.
Okay. And despite her claiming that these incidents had happened, she continued to talk to him, right?
Yes.
Now, you told us that you set up an interview with Ms. Betancourt at the Ralston House, right?
Yes.
And the Ralston House is a child advocacy center, right?
Yes.
And just to be clear, Ms. Betancourt she's in her 40s, right?
Yes.
And she doesn't have any developmental delays that we're aware of, right?
No.
It just so happened that you set it up at the Ralston House.
I contacted the Ralston House and they stated they'd be more than willing to conduct this interview.
Okay. Now, the date range charged in this case is March 15th of 2026 to March 25th of 2026. Are you aware of that?
Yes.
Okay. Are you generally aware of how inmates make calls while they're in the Department of Corrections?
I'm not familiar with the Department of Corrections and how their stuff is conducted.
Okay. And you didn't do that investigation, even though you're the lead detective in this case?
No, that was something that another deputy was working on.
Okay. And so you've delegated that then?
Yes.
Okay. So let me ask you this. Do you know what Department of Corrections facility Mr. Vargas was at during the dates charged in this case?
I do not recall. I was informed, but I don't recall at this time.
Okay. And so you don't know how inmates at that specific facility make calls?
No.
Okay. And I don't know if you know the answer to this, so you can just tell me. The person who is receiving the calls while at the Department of Corrections, so in this case, it would be Ms. Betancourt, does she need to be on a phone list for the inmate to call her?
I can't attest to that. I do not know.
Okay. Do you know that if the person who's receiving the calls, Ms. Betancourt, can then block calls from the facility?
I would imagine it wouldn't be any different than any other phone calls, but I don't know for sure.
Okay. Meaning that people in their daily lives can block people from talking to them, right?
Yes.
If you call me too many times, I can block your number.
Yes.
Or if I just don't want to talk to you.
Yes.
Okay. Now, Ms. Betancourt told the Ralston, well, let me back up a little bit. You yourself did not personally speak with Ms. Betancourt, right?
Not till after the interview.
Okay, everything was done through the Ralston house.
Yes.
During this interview, she testified, or she told the interviewer that there was an expectation that she would answer the call, right?
Yes.
And that if she didn't answer the call, Mr. Vargas would be upset,
Yes.
right? But again, Mr. Vargas is incarcerated, right?
Yes.
And Ms. Betancourt, she's out doing whatever, right?
Yes.
And it's fair to say that she's the one who decided to answer the phone calls, right?
Yes.
She has free will, right?
Yes.
And she made that choice.
Yes.
Now, the prosecution talked to you about this argument about the bet that happens in March of 2026, right?
Yes.
It's the $300 versus $30 bet. You know what I'm talking about, right?
Yeah, I think it was 10 versus something and the payout was different, but
Okay.
yeah.
But we're all talking about the same argument,
Yes.
right? And it's fair to say that after this argument, the two of them never speak again, right?
Not to my knowledge.
Ms. Betancourt also explained that she would change her phone number, right?
Yes.
But then ultimately she would give her new phone number to one of Mr. Vargas's family members, right?
I believe that was before the bet.
Yes, I'm talking about before the bet.
Okay, yes, before the bet, yes. It was to his mother, if I remember correctly.
Okay, because after the bet, they never talk again.
Yeah.
Okay.
Yeah.
Before the bet, she'd get a new number and then she would give the new number to his mother, right?
Yes.
Because his mother would explain to her that, he missed her and he wanted to talk to her.
Yes.
Again, she didn't have to give that new number to anyone, right?
No.
She made a choice
Yes.
and she has free will.
Yes.
Those are my questions. Thank you. Oh, wait, I have two more questions. I'm so sorry. When the forensic interviewer talked to Ms. Betancourt, she had deleted all of the messages from Mr. Vargas, right?
Yeah, that's what she stated to me after the interview.
Oh, she said it to you specifically?
Yes.
Okay.
Because I asked her about it after the interview.
Okay. Because it would have been helpful if you could screenshot or take photos of more messages,
Yes.
right? It would have been helpful if you could photograph or screenshot or record more recordings, right?
Yes.
She had also deleted every recording on her phone.
That is what she stated.
Those are my questions. Thank you.
Any redirect?
No, Judge.
May this witness be excused?
Yes, Judge.
If you can step down, Detective.
Thank you, Your Honor.
Any additional witnesses?
Not from the people, Judge.
Any witnesses for the defense?
No, Your Honor.
And then real quick, for the people's exhibits, I have 1 through 7. I have 8 being introduced but not admitted. Do you want this one back?
Sure.
And I confirmed with Crystal that I did miss something and I'm not crazy on that. All right. And then in terms of People's Exhibit 7, do you have a disc that you could have somebody make and run up? Just so
Yes,
we've got
Judge, I
that
can,
at 17 minutes?
I can do that after the hearing, if that's okay.
That's fine.
Would it be fine for me to have till tomorrow to have them?
That's fine.
Do
Is that
that.
okay for the defense?
That's fine.
All right.
Thank you. Thank
All
you.
right. Argument on the hearing for the people.
Thank you, Judge. Just one moment, please. Judge, as the court is aware, preliminary hearing is a screening tool, and it's not intended to be a mini trial. Purpose is to screen cases for determination as to whether or not there's probable cause to believe the crimes as charged have been committed and committed by the defendant. There's a long line of cases that go through that standard: People v. Thornton, People v. Sutherland, People v. Ayala. In addition, Judge, the burden is, as stated, is probable cause, but there are some things that the court cannot consider at a preliminary hearing, and one of those things is credibility. So while a jury is the fact finder and may determine that they find things that the victim did or did not do credible, such as deleting some of the messages, that's not something that is before the court. The court could find a witness incredible as a matter of law, because the witnesses who appeared before the court today could be subject to that, but I would submit that there's nothing that would indicate that the court in this circumstance would make a credibility determination such as that. Both of these are officers that testified in the people's determination credibly. All reasonable inferences must be drawn in favor of the prosecution. If there is a conflict in testimony, that becomes a question of fact that exists for the jury. And that's People ex rel. Hunter v. District Court, 543 P. 2nd, 1265, Colorado Supreme Court, 1975. As to whether the people have presented competent evidence, as we're required to do at a preliminary hearing, the people would submit that the prosecution has done that. As the court knows, pursuant to CRE 1101D3, rules of evidence don't apply to preliminary examinations in criminal cases, and Criminal Procedure Rule 54, Roman numeral 2, rules of evidence may be tempered in the use of sound judicial discretion. Hearsay evidence can be the bulk of the evidence at the PH. However, Judge, there are numerous cases that talk about direct evidence that would be sufficient. I have two officers here. They're investigating officers. That's different from a case where a detective might testify who really did nothing on the case, just reviewed the reports and is testifying completely about someone else's work. So for instance, examples of direct evidence that have been held to be sufficient would be investigating officer's observation of the victim when she made her complaint, such as a demeanor. And that is People ex rel. Van Meveren v. District Court, 575 P. 2nd, 405, Supreme Court from 1978. In addition, Your Honor, it's the other evidence that they collected, and such as the calls, such as the recorded phone call. And although Exhibit 8 was ultimately not requested to be admitted and not admitted by the court, it's sufficient for there to be testimony about the identification procedure that the officer went through, and also that he verified that identity through the criminal history. And that was Officer Ellsworth, and Detective Neal also talked about the fact that the defendant was in custody at the time and was set to be released from the Department of Corrections less than a month from the time of this incident. In addition, Your Honor, the people, just to supplement that, just for the purposes of the record, had filed more than one notice with the court, alerting the court of the defendant's status. And as an officer of the court made rulings based on that, and the people submitted that as an officer of the court. Judge, this potentially could be a different case if a couple of things had not occurred. If the defendant, by the burden at preliminary hearing, had not had other individuals reach out to the victim. It's on his criminal history. Tiny Pesos is a name that he goes by. They got that information from the victim for the purposes of probable cause. And the defendant in his own call talks about having people reach out to her and making that threat to her. It also, Judge, could be different, although I will state that there is nothing in stalking that says that somebody has to complete a threat or somebody has to be able to complete certain acts. And there's nothing in the case law of stalking that says it couldn't be 4,000 phone calls from somebody who never has contact with that person in person. However, what is significant in this case is that he ultimately was about to be released. And so in the assessment of whether a person, for the purposes of count 2, a reasonable person would think that this threat was credible, Judge, I submit that we've met the burden for the purposes of PH, that the threat is credible in this case, and that he would knowingly, although as the court knows, via Counterman, the Supreme Court case, they deemed that the burden was recklessly, that someone would recklessly know that a statement they made would cause a reasonable person to believe that the threat was credible. That's what we're talking about here in terms of that threat, Judge. The court heard itself, the things that he said. It's also contained in a filing by the people and was stated also on the record and played on the record here today. He talks very clearly about the fact that he knows where she lives, and it doesn't matter where he got that information. He knows where she lives. He knows her schedule. He also knows people that know her. He talks explicitly about what he's going to do when he gets out. And Judge, for the reason that the people elicited the testimony about the prior incident, and I should say plural incidents, is that goes directly to the court's assessment of whether a reasonable person in that position would think that a threat was credible. The victim is aware that not only was he violating parole, that he was in Department of Corrections, and prior to him going back to the Department of Corrections, he engaged in domestic violence behavior. I understand for the purposes of the trial, the court may need to make determinations, but that's down the road as to what does come in or does not come in. For the purposes of preliminary hearing, it's proper. And Judge, there are cases that talk about that one of the things that's important for a court to potentially consider in stalking is something such as motive. And that's the Casper case, 577 P. 3rd 489, Colorado Court of Appeals from 2025. In that case, some of the facts include whether the contacts by the defendant were a motive or retaliation to the particular victim in that case. And Judge, as a result of a police call that came from her house in 2024, he went back to prison and burned the rest of his time and was not released until April. And if there's not a bigger motive than that for somebody who's violating parole, I don't know what the motive would be. So Judge, in terms of true threats, what he's talking about is not protected speech. It's not speech that someone is saying in a public forum. It's not speech that's political speech. It's specifically directed to her and pursuant to the case law. It is speech that talks about a future act of violence that could be committed. And that's from the Colorado case of Crawford when it talked about true threats. And that's 568 P. 3rd 426 Supreme Court 2025. Judge, so the people would submit that we've met our burden. I would also note that pursuant to the statute, the continuing course of conduct that's required in connection with the credible threat, and this is 183602, can be before, during, or after the credible threat. And so it's not the case that it has to be someone makes a threat and then they have additional contact. It can be any time during that period of time. Judge, in addition, count 1 is not based.
Before we go on to that,
Yes.
real quick, I just wanted to, because that was sort of my question on count 2 for the credible threat and then the repeated communication that has to be a connection to the threat that was made. And so I was just actually reviewing Casper 2, and it looks like that was an email case where there was a threat and then emails. And those follow-up emails substantively dealt with the threat in question, right? So in a case where somebody's calling repeatedly and there's nothing, I didn't hear any testimony about voicemails or any substance of those messages. I guess, what do you think that the court should consider when looking at the follow-up communications and whether those are in connection with the original threat?
Your Honor, the original threat occurred on, at the time that the bet had occurred on March 15th.
And that was the one where if I see you at the gas station, you don't have
Yeah.
your kids, I'm going to
Yes.
put your ass in the car.
And Judge, those, and then he starts calling her, that same day, starts calling her hundreds of times a day. And you can see from this time, the time stamps, that coupled with kind of the history that the court heard about, she knows what's coming for her if she doesn't answer the calls. So now there's that credible threat. He then is also contacting her. And then on the subsequent days, he is contacting her through that 3-day period of time. Actually, let me correct myself. There's contacts Sunday, there's contacts Monday, and then there's contacts Tuesday. So all of that is connected to the bet that he was really mad at her for because he thought that she was lying to him. What's significant to the people and goes to the nature of the concern in terms of both her emotional distress, but also the credible threat is this is over like $10. I mean, it's whether it's $10 versus $100. So I think all of it is connected for the purposes of the credible threat. Makes a threat and continues to contact her. And I think because I looked into that too, and what's compelling to the people is that the statute specifically says it could be before, during, or after. And I think it's the context that's important because it's all interconnected. Judge, as to count one, there's not even a requirement of specific things being said. And that's consistent with the case law in Crawford and other case law. It's really about the number of contacts. If somebody contacts somebody 200 times and it causes them emotional distress, which occurred in this case, she's worried for her kids. She took the significant step of moving. She changed her phone number. She was scared when she made this report. She was scared about reporting it. She was crying when she reported it. For someone to change their entire life and significantly to go to their boss and say, I want my life insurance beneficiaries to change. I'm afraid that something is going to happen to me. For the boss to be so concerned that the boss encourages her to go to the fire station and report this, all of that goes to emotional distress and what she had gone through and how she had reacted in response to this. There are times when the court knows this could be a case, and it's not, where somebody contacts somebody 100 times and they don't move or they don't change their phone number. There's nothing in the case law, and this might be something for the jury to consider, but for the purposes of PH, it doesn't matter if she answered the phone or not. That's an issue for the jury to determine. Why did that person answer the phone? It doesn't matter, Judge, if she could have changed her number yet another time. There's no requirement that says, well, you have to change your number 10 times or it's not stalking, or you have to move 4 times or it's not stalking. And some of the context around that is that she tried to change her number and that it was unsuccessful. And during that time, he's putting pressure on her even before this stalking date range, where he's calling her at work. She's having to watch games at work. She's having to sneak around at work to get his calls, because if she doesn't respond to those calls, there is negative impact for her. And so, Judge, I would respectfully suggest that for the purposes of PH, the people have met their burden as to count 1 and as to count 2. However, if the court has any other inquiry, I'll answer it.
Thank you.
Thank you.
For the defense.
Your Honor, I would note, I really have 2 issues with both counts, and that's the identification as well as the venue in this case. The identification testimony that came out was that one of the police officers was able to claim that he was able to identify Mr. Vargas in court. During the follow-up, we learned during cross-examination that the way he's able to do this identification is he plugged in Adrian Vargas in a couple databases, Lumen as well as the DMV, and that he got a picture of this Mr. Vargas. He doesn't then take the extra step where he shows that picture to Ms. Bedencourt to confirm that this is the same Adrian Vargas that she is talking about. And so I think we're missing a link in terms of identification. Ultimately, People's Exhibit 8 did not come in. It wasn't admitted as evidence, and I don't think that the court can consider that as part of the identification in this case. So really, we're missing a link that this Adrian Vargas is the one who was supposedly making the phone calls to Ms. Betancourt. My second issue in terms of the county that this is charged in is that the only testimony we heard about, whether Adams County is related is that a deputy from the Adams County Sheriff's Office, who normally investigates things that happen in Adams County, happened to go to a fire station in Adams County where he met up with Ms. Betancourt. We heard no testimony that, I understand things can happen in two different counties, and certainly they probably happened in two different counties here, but we know for a fact that Mr. Vargas was in Canyon City in the Department of Corrections, but we heard absolutely no testimony where Ms. Betancourt was when she received these messages, and especially when he made that phone call on May 15th that caused basically a ruckus. And so ultimately, I don't think the DA has proved identification. I don't think they've proved venue. On all other issues, I would rest on the record.
Thank you. And counsel, any response on the venue issue?
Judge, it's state of Colorado is for the venue. I think for the purposes, and that was what the charge would state, for the purposes of preliminary hearing, the people have demonstrated why it was an Adams County investigation, that the response was in Adams County, and I would just rest on what the jury instruction is going to say, Judge, and for the purposes of PH. In addition, I don't know if the court, for the purposes of identification, I think, Judge, it's circumstantial evidence of ID in addition to the testimony about ID, whether 8 comes in or not. That phone call, they're talking about things that are related to this case, talking about exactly the bet that was placed, that's circumstantial evidence of ID. The other things in that the court heard, circumstantial evidence of ID, his criminal history, where he was at the time, the things that he was referring to, and also the AKAs in his criminal history. So the people would state that we've met the burden.
Thank you. So it sounds like the people are going to bring People's Exhibit 7 tomorrow morning. We're in PHs all week. But we are in drug court on Thursday, so we'll probably have a covering judicial officer. My thought is Wednesday. That would give me time to listen to the recording and then bring the parties back in for PH.
Your Honor, I can't come back this week. That's part of my issue. I'm fine if the court makes a written ruling.
No. I've told all clerks to hit me over the head with a frying pan if I ever say I'm going to make.
I start a trial on Wednesday. It's supposed to go for a week and a half. And I would really like to not come tomorrow.
Well,
I can message somebody right now and see if they can start working on it, and I come back to the office and come over. I just don't know who's available, but I'll message them right now and see if they can burn a disc.
no worries. That's okay because
Yeah.
it sounds like she's going to be in trial prep tomorrow. and then out for a
Alternatively, I
week.
can get someone to just cover the ruling. Like Ms. Jones.
That sounds
my-
great to me, Ms. Jones.
my
It's ready,
co-counsel.
willing, and able. Does that sound okay? All right.
I would like to argue his bond today, though.
Oh, go ahead.
Okay, so,
Why don't we say Wednesday then?
Wednesday, that's great. Okay, thank you.
Would it be in the morning, Judge?
Could we do 10:30?
Yeah.
Ms. Jones? That's wonderful. Ms. Salibi?
I'm sorry, Judge, I'm covering for, I know this is probably a problem that I created, but I'm covering for someone who's out. Is it at all possible to do it 11?
Yeah, we can do that.
Okay.
That's fine. 11 on Wednesday. Oh, go ahead.
Your Honor, Mr. Vargas's bond is currently it's currently at $50,000 cash surety. I'm requesting a reduction to $5,000 cash surety, and he would be willing to do any conditions of the bond that the court imposes. This includes GPS, SRP, obviously no contact with the victim. The court heard that after this argument on May 15th, they've had no contact since then, and it's ultimately not Mr. Vargas's position that he wants to contact her in the future. As the court heard, this was a crime that occurred when Mr. Vargas was in custody at the Department of Corrections, and he was in custody for close to 2 years, probably talking to Ms. Betancourt throughout this entire 2-year period. But I would recognize that this case is only charged as a 10-day date range. And so really, I think this stemmed from that argument that they got that the court will listen to and the phone calls. I can tell the court that Mr. Vargas has since completed his sentence at the Department of Corrections. He was then transferred to Adams County to deal with this case. And I can tell the court that he does not want to have any contact with Ms. Betancourt. I know the court didn't hear evidence of this, but I can tell the court that after this occurred, he did write her a letter where he found out that he was wrong about how much money the bet was. He found out it wasn't a 10 for 30, but it was a 100, and well, it wasn't a 100 for 322, it was a 10 to 30, and he was mistaken about that. And ultimately, in that letter, he wrote that he was sorry that he yelled at her, and that he would just leave her alone, and he's had absolutely no contact with her. Obviously, he wishes her well. He wants her to be happy, but they're not going to be talking in the future. I can tell the court that, while we can think of $300 as just being a small amount of money in prison and under the conditions that Mr. Vargas was in, which was solitary confinement, as the court heard on the recording, given the amount that people in prison make per hour and given the amount and cost of commissary, this really was a very big deal for Mr. Vargas. Did he overreact? Absolutely, which is why he's tried to make amends. I can tell the court that Mr. Vargas has decided to go to a preliminary hearing on this case because he wants to fight this case. And that ultimately means that he's not going to be a flight risk. Mr. Vargas has always pled guilty in his other cases, and he always, takes responsibility for his actions, but ultimately he really didn't have any ill intention. I can tell the court he doesn't have any out-of-state criminal history. He's lived in Colorado his entire life. His criminal history really consists of, I can tell the court, it's 4 prior felonies, a menacing in 2021, a leaving the scene of an accident in 2020, a motor vehicle theft in 2020, and a robbery back in 2016. And so his criminal history really spans a long period of time. I can tell the court his family lives here in Colorado, including his mother and father. His brother had planned to come to court this morning, and he has lived here his entire life. He does have a 14-year-old son here in Colorado that he's very close to. Mr. Vargas has already missed out on his continuation graduation, and it's something that he really regrets. Ultimately, the bond suggestion for a Class 5 felony is normally $3,500. The bond suggestion for an F5 stalking case is $10,000, meaning that, whoever made the bond suggestion, probably Judge Steedore, has already taken into account the increase for a stalking case on a Class 5 felony. And so I would be asking, at the very least, for the court to reduce the bond in this case. That's all I have.
Thank you. People's position and VRA record.
Judge, the people are in VRA compliance. The people, after doing that compliance and on their own, object to any change in the bond. Judge, I had filed a motion on April 8th of 2026. I don't disagree with defense that the chief judge, through his administrative order, has established bonds, but those bonds are simply for the charge. That's it. It doesn't take into account anybody's prior history. As I stated in that motion, he does have those prior felonies. However, in paragraph 6, the court can see, and this goes to whether somebody can be maintained in the community, that in each case, he violated his sentence. The direct sentence to community corrections in 20 CR 3790 was revoked. Also in 5909 was revoked. In 2560 out of Arapahoe, probation was revoked and reinstated. Direct sentence to community corrections was revoked. He's had continuous issues in community-based environments where he had the opportunity and was monitored. In addition, his history indicates failures to appear and arrest for other jurisdictions and failures to comply in a parole violation from September 26 of 2024. Ultimately, it's significant to the people that he was released on parole, but then went back because he had violations of parole. So then he ended up just serving his entire sentence in the Department of Corrections. Judge, his history and his lack of compliance in community-based settings, also his specific threats to the victim, which the court heard some of and articulated in the people's motion, indicate to the people that the bond is appropriately set. And he's differently situated from someone with no criminal history, and he's differently situated from somebody who doesn't make threats that specific, and he's differently situated from somebody who's not allegedly reached out to other individuals to contact a victim in the course of his efforts to threaten her. And as I stated previously, Judge, this is over a $10 wager. And the things that he said on that call are, to say the least, shocking and frightening, even to a reasonable, average outside person. I would object strenuously. Thank you.
So I haven't listened to the call yet. And then one thing I was just checking for, I don't see a pretrial services report with any sort of CPAT. What I'm really looking for is the failures to appear and their assessment and how many points he lands with.
I
The
think,
parties don't happen to have that, do you?
no, I
don't
think,
see
Judge, it's
anything.
because he was in Department of Corrections. Once
When he
they
got the
quote
warrant.
unquote detained him, they brought him over. I don't know that the court was aware, so I don't know that they ever did the CPAT. I'm not in possession of one.
So I feel a little bit hampered without that benefit. And then based on what I've heard, I'm not going to grant a reduction. I note that the amount requested on the complaint from the people was $250,000, and this has been set at $50,000. So I'm going to leave it where it's set. I don't know if we can trigger, though, a pretrial services report, and then if there's anything for any reviewing court to take into consideration if bond is readdressed. Can we try to trigger that?
Yeah.
Did parties have any objection to doing that?
That would be fine with me. Thank
No,
you.
Judge.